Hello. Well, good afternoon if you're on the East Coast, and good morning if you're way out west. You are tuning into the latest installment of the Higher Education webinar series offered by the higher education practice of the law firm of Thompson Coburn LLP. We are glad you're here. Today we're going to be talking about bar defense to repayment and specifically responding to student bar defense to repayment claims. While folks are still joining, I thought I'd get through, as we typically do, a few housekeeping items. First of all, if you have any questions during the webcast, we encourage you to submit them through the Q&A widget at the bottom of your screen. As always, we'll try to answer as many of these questions as we can at the end of the webcast. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that are there and that you may find useful. And if for some reason we reference a resource during the presentation or in the resource widget you are unable to locate the slide deck or other items, just shoot us an email and we are more than happy to send it your way. You can find additional answers to some common technical questions located in the help widget at the bottom of your screen. We're all about the widgets. The webinar today, if you are a lawyer type, is CLE accredited. That's continuing legal education. It's accredited in California and Illinois for an hour of general CLE credit, and in Missouri for 1.2 because that's where we're located, and I guess we're worth more there. The webinar is also CLE accredited in New York for an hour of experienced and transition credit, and for 1 hour of general CLE in Texas, or at least it's pending, and it should be done there pretty soon as well. We award CLE based on attendance for the entire 60 minutes. So if you are here for the CLE credit, please make sure that you tune in for the full 60. In addition, due to changes in jurisdictional requirements, you will notice that we're no longer using automated pop-up attendance checks. We're now required to use secret words again, and some of you have been around with us for a long time. Remember that we used secret words several years ago. So during the presentation today, you'll see some secret words pop up. There will be some multiple choice options, and we'll just need you to select the correct one to show that you're still in attendance. If you have questions regarding CLE and things along those lines, you can email us about those as well. We're always happy to. I mentioned that this is the law firm of Thompson Coburn LLP. I discovered a few years ago that if I did not mention that we were a law firm, sometimes people didn't realize that. So the folks presenting today are lawyers, and we give legal advice for a living. We have locations all over the place these days, but I and my partner, Jeff Fink, who's presenting today, are both here in St. Louis, so we're looking out over the arch, as it were. My name's Lacey. I'm the chair of the higher education practice here at the firm and have been doing this for a couple of decades now and have my entire career worked with institutions of higher education. I'm delighted to do it, and we and the colleagues of mine here that also work in this practice do all kinds of things for institutions of higher ed, whether that be sort of on the transactional side or regulatory. Much of what we're talking about today would fall into that bucket. And also when it comes to litigation, administrative proceedings, things of that nature, which brings me to my good friend and colleague, Mr. Jeff Fink, who's a partner in our litigation practice, but spends lots of time working with our higher education clients and doing things that are more litigation focused or feel like litigation, right? So managing litigation, of course, but also representing schools, program reviews and audits from the department, accreditation disputes, issues with federal and state regulators, and, as you would expect, working with institutions to respond to borrower defense to repayment complaints that may come their way. So Jeff is going to be our featured presenter today. We're going to split the presentation, and then I'd say the latter sort of 60%, we're going to spend some time asking him questions and really getting his perspective on how to do this and do it the right way. Here is the syllabus for today. First of all, I just wanted to talk a little bit about the latest edition of Bar Defense. Those of you out there who follow the regulatory machinations inside the Beltway are probably aware that the department once again is renegotiating and reconsidering this Bar Defense rule. It's called BDR 4 because this new version would indeed be the fourth to come along. The next thing I want to do is just do a quick 5 or 10 minute refresher for you all on the current bar defense framework. You know, I had a client who said to me not too long ago in passing, well, it's going to be really difficult once this bar defense rule comes along. And this was, you know, in the last 6 months. And I said, well, you know that's already out there, right? And there was sort of a pause, and I thought, So we figured today it would be worthwhile to remind everyone that while the department is negotiating the latest version, there are 3 prior versions that were created. And that, if you're getting a complaint filed right now, it's actually going to be processed and will be for some time under those current versions. So I wanted to just go through that. And then we're going to switch over and start our discussion with Jeff, which really is focused on if you do get a bar defense claim, what's the best way to go about thinking about it and responding to it and preparing for that even. And, of course, all of that is born out of his experience managing hundreds of these, in fact. And then finally, we'll spend just a little time on some TC extra credit. So with all of that having been said, let's jump on in. As I mentioned, the first section here, BDR for cometh. So the U.S. Department of Education, the Biden administration's department announced pretty early in 2021, actually, that they wanted to revisit a wide range of regulations or topics within the current regulations and reconsider them and rewrite them, right? And they had 15 different topics that were listed in a Federal Register that came out last spring. And one of those, and you'll see there's a red box around it here, was bar defense to repayment. In the past, there have been rulemakings that have been referred to the, quote, bar defense to repayment rulemaking. But sometimes those rulemakings have involved consideration of a number of different topics. What we're really focused on today, just to be clear, is the bar defense claim process, which is the process by which a borrower who may be a former student of yours, right, says, you know, my institution did something to me that wronged me in such a way that I should not have to pay back my student loans. And they file a complaint with the U.S. Department of Education, and then the department adjudicates that claim through a process and decides whether or not to discharge the student loans. And it's important to understand there's actually a secondary recovery proceeding. So the first piece is the adjudication of the initial claim between the student and the institution. And if the department does determine to discharge whatever amount they discharge, so let's say that's $20,000 in loans, then they have the opportunity through a secondary proceeding to turn around and attempt to recover that $20,000 from the institution that the borrower attended. And it's that claim process, that first act of filing the claim and then the adjudication of that initial claim and then the recovery proceeding, that is the foundation of what we'll call the bar defense to repayment sort of scheme or process or framework. And that's, again, what we're focused on today. As you can see from this slide, I mean, that is only one of 14, 15 different topic areas that the department has been considering. And, of course, even some of these that you see on your screen are quite broad. I mean, when you talk about standards of administrative capability, which you see in the middle of the top row, I mean, that's a big topic. There's a whole lot that fits in there. So it's safe to say right now in D.C., the department is in the process of reconsidering lots and lots and lots of their regulatory framework. Just to keep you updated, they've actually split those topics into 2 tranches or 2 rulemakings. The first was the Affordability and Student Loans rulemaking. It's actually ongoing. I shouldn't speak of it in the past tense. But the negotiated rulemaking rounds, where they brought people all together, used to be in person. These days it's on Zoom, but where they actually had 14 or 15 plus negotiators all considering these topics and providing feedback for the ASL rulemaking that occurred late last year, 2021. And all of these topics were considered, including bar defense to repayment, or BDR4. The department, these days, it has become customary during those negotiated rulemakings that they will actually issue draft versions of the new proposed rules, whatever they're thinking about. Now, to be clear, this is not a proposed rule in the formal sense. Formal proposed rules appear in the Federal Register, and there's a comment period, et cetera. This is literally just the department putting out a draft, saying, look, here's what the current regs look like. Here's a red line showing what we're thinking about doing. And they put that out so that the negotiators can talk about it during neg-reg, which is how the cool kids, by the way, say negotiated rulemaking. We say neg-reg. So if you're in the grocery store and you meet somebody, say neg-reg, and they'll know you're one of the cool kids. Bar defense to repayment, then, has already kind of been previewed, right? So we got to see last fall what the department is thinking about, this administration is thinking about doing. It's also worth noting that right now we are in the middle, we're between the first and second round of the second rulemaking effort that this administration has in place right now, the institutional and programmatic eligibility rulemaking. Lots of very important things being discussed there as well. But for purposes of today's presentation, I just wanted to highlight that bar defense to repayment was considered last fall, and BDR4 is in the works. this was the little consensus scorecard we crew. We know the department loves the scorecard, so we made our own little scorecard from that ASL rulemaking, and it just shows you where consensus was reached, meaning all the negotiators agreed on certain topics and the topics where they did not all agree. And as you'll see, first item, left-hand column, bar defense to repayment did not achieve consensus. So what that means is right now the department has the opportunity to go back and create a proposed rule that is more or less consistent with its own designs. And we would expect to see that proposed rule come over the transom probably in May of this year. Speaking of timelines, just so you have it, I'm not going to go through all of this, but this is an integrated rulemaking timeline. Goes back to April 2021 when the department first announced actually that it would also be overhauling the Title IX regulations. So this includes Title IX as well. And then you'll see references to the affordability and student loan rulemaking, as well as the programmatic eligibility, institutional programmatic eligibility rulemaking. And if you click on these little links, those are active links, and you can go to the underlying Federal Register notices. This is also what we think this year is going to look like, 2022, and you'll see right here in May, we think that ASL rulemaking, the proposed rule is going to show up, which includes bar defense 4. Really encourage folks in the higher ed community to consider filing comments to those proposed rules between April and September. And then our expectation is that the department will get a final rule out by November 1st of this year to include bar defense, meaning that a new bar defense 4 rule would become effective most likely next July 1, 2023. If you want to follow what's going on with all of this negotiated rulemaking, if you want to see the issue papers as well as the red lines and comments different negotiators have proposed, you can go to the department's NEGREG page, and there's a link right there for you. In addition, if you like, last December we talked about the ASL rulemaking, and if you're particularly interested in some initial views on the bar defense 4 rule that has been proposed in draft form by the department, we commented on that quite a bit in this webinar. It's free, it's online, you can watch it if you like whenever you want. And we assure you, pledge to our listeners, that we will be providing more content in the coming months of 2022 covering the proposed rules as they come out. And then the final rules probably in December, January, February of next year. So we anticipate as part of this higher ed webinar series and otherwise, preparing a lot of outreach to you all and trying to keep you up to date. So please, if you're interested in these regulatory topics and these rulemakings, keep an eye out for our webinar announcements as they come across the transom. Okay, so that's what the department's working on. But if you get a bar defense claim today, as you would expect, it is not going to be managed pursuant to a process that is still being negotiated. It's going to be managed pursuant to the process that is in the books right now. And it's really important, again, I'll just emphasize that everybody understand there is a bar defense rule right now in the law, right? In fact, it's been there for a long time. The department put the first BDR 1 rule into place way back in 1994. And again, I'm not going to go through all of this right now. This is for your edification and use as a tool if you do want to go back and look at some of these developments. But what you'll see here as you go through it is just generally that we had a first version of the rule, and then many years later in 2016, the Obama administration introduced a second version of the rule, BDR 2. Then there was a lawsuit, and the implementation of that was delayed, and it didn't actually become effective, if you go to the next slide, until some point in October of 2018, which was very confusing because about the same time the Trump administration introduced BDR 3, which is its version of the rule, and that became effective July 1, 2020. So you say, okay, Aaron, then that must mean right now, if claims are filed, that means they are being considered and processed under the Trump version of the rule, BDR 3, which is the most recent rule to become effective. Unfortunately, that is not the answer. These administrations have gone about implementing new versions of the bar defense rule in a way that has, it's been structured in a way such that each version of this rule continues to apply to loans that were first dispersed during certain periods, right? So that BDR 1 rule that was put into place way back in the 90s is the rule that we look to for when we're talking about what constitutes a bar defense claim for any loan that was dispersed prior to July 1, 2017. Now that's if we're trying to understand the standard, like what is a bar defense claim. When you talk about process, right, any loan that was first dispersed before July 1, 2020 actually is managed right now under the Obama era process. And if a loan, the underlying loan, so when I say the loan, I mean if a borrower is saying I want to have a loan discharged, it's that loan that we're looking at, right? So if that loan was first dispersed between July 1, 2017 and July 1, 2020, it's not only is it managed under the Obama era process, it's also managed under the Obama era definitions of what constitutes a borrowed defense to repayment. So in other words, is it a misrepresentation? Is it a breach of contract, et cetera? Like what can a borrower assert? The Trump era version of this rule, both with regard to what constitutes a borrowed defense, the standard itself, and the process, only applies to loans that were first made on or after July 1, 2020. Now, if you just sort of think about the math quickly here, the vast majority of loans that are outstanding out there in the U.S. government's portfolio, right, were dispersed before July 1, 2020, right? Which means that the vast majority of loans that are out there right now, if a borrower were to assert a defense, would be adjudicated under the BDR1 or BDR2 standards and processes, right? The vast majority. So if you get a borrower defense claim, unless this is a borrower who graduated pretty recently, it's more likely you're dealing with these BDR1 and BDR2 standards. And that will, the way these laws were designed, there's nothing that's going to change that anytime soon. Interesting side note, now the current administration in BDR4 is attempting to redo this. And they actually are trying to pass a regulation or create a regulation that would say, you know what, on a go-forward basis, if anybody submits a borrower defense application after July 1, 2023, even if that, it doesn't matter when the underlying loan was issued, it doesn't matter when the underlying conduct that the institution supposedly engaged in occurred, everything in that case would be dealt with under the new BDR4 standard. And of course, there's a real question there about retroactivity, et cetera. So if you're looking at this and you're saying, this seems very confusing and like a real mess, you are not alone. You are not alone. It is a real mess. And I think there's a legitimate question to be asked as to whether or not the department has a sufficient number of staffers on board who really understand all these distinctions and are prepared to apply these different standards. There also can be the absurd situation where you could have a borrower who entered, say, a 4-year undergraduate program, you know, in the fall of 2016 and graduated. Maybe they took 5 years to graduate and graduated in spring of 2021, and they could have loans that were issued across all three of these. So it could be a real challenge to figure out. And it does make you wonder whether the department is up to the task. I also think the department knows this, and this is one of the reasons they're trying to figure out a way to eradicate some of this inconsistency and confusion and create a single standard that would apply to everything. But right now, this is what we've got. We've got 3 versions of borrower defense. Let me just give you a really quick overview of what the differences are, just one slide on each, because I know we want to get to Jeff. So for BDR1, again, these are loans first dispersed prior to July 1, 2017. The standard is simple, and there's just one. Whether or not the act or omission that the school engaged in would give rise to a cause of action under applicable state law. So that's the only basis for any loan that was dispersed prior to July 1, 2017. The only basis upon which somebody can make a borrower defense claim is if they say their school did something that gave rise to a cause of action under state law. Of course, the problem is, how's the Department of Education, some staffer at the department, and I don't mean that to be pejorative, it's a huge task. How are you supposed to go back in time if the thing occurred 5 or 6 or 7 years ago and figure out if whatever they're saying happened would have violated a state law in the applicable state way back then? I mean, the laws could have changed. And then there's the question of what state we're talking about. What if it's an online program and the student is sitting in one state and a resident of another and the school's in a third? It's very confusing, and it's one of the big reasons why you have this big backlog of borrower defense claims dating back to between sort of 2010 to 2020, largely involving Corinthian and ITT and some of the other schools. It's because all of those have to be, or at least are supposed to be, administered under this standard, and it's very difficult to carry out. Way back in the 90s when somebody created it, it just had not apparently occurred to anyone that in practice it would be very hard to administer. The evidentiary standard, in other words, what the student has to be able, or the borrower has to be able to show, is that they were wronged based on a preponderance of the evidence. So, you know, whatever they're able to provide and whatever the department has on hand, it's more likely than not that it demonstrates that they were indeed wronged. This is resolved using the BDR2 procedures. So the actual claim process, even if it's a BDR1 standard, is going to be the Obama-era BDR process. There's no time limit for claims, right? So even if the student was wronged and graduated or didn't graduate, but claims that the thing occurred 20 years ago, they can still bring a claim under BDR1. But under current law, or at least under the BDR1 framework, the department was limited in how long it could go after schools. So there did come a point where even though a student could still file a claim and potentially get a discharge, the department could no longer turn around and go after the school, which created exposure for the taxpayer. So here's the Obama-era rule in a nutshell. Again, only applies, at least the standards, only apply to loans, claims that involve loans that were dispersed on or after July 1, 2017 and before July 1, 2020, which is when the Trump-era rule went into place. There were more bases to bring a claim. So the Obama administration introduced judgments, breach of contract, or substantial misrepresentation. The evidentiary standard remained preponderance of the evidence. There was both an individual claim process, and the Obama administration introduced a group claim process that, for the lawyers in the crowd, looked and felt much like class action, and it could be initiated by the department even if in the absence of individual claims having been filed. So in theory, without a single individual claim being filed, the department could sort of look at a situation based on information it had and say, we're going to sort of certify a class because we think all of these individual borrowers are eligible on the same basis for a discharge, and there was an assumption of actual reliance in that case too. Time limit for claims, both for claims themselves and for recovery actions, were tied to statutes of limitations and notices for claims. So it was kind of complicated, but it wasn't sort of the simple approach under BDR1. All right, BDR3, this is the Trump-era rule that came along. Applies to loans first dispersed on or after July 1, 2020. The Trump administration said, we really think there should just be one standard, but instead of using the definition of substantial misrepresentation that exists right now in the law, we're going to come up with a specific federal definition of misrepresentations, specifically for the BDR process. Preponderance of the evidence was the evidentiary standard. The Trump administration introduced the idea that the borrower needed to show that they suffered some monetary harm, which highlights the fact that under BDR2, there was no requirement that the borrower show that they had actually suffered any harm. Right? There was a simplified single process for individual claims. The Trump administration did away with the group claim process. And then they had new time limits. So the time limit, 3 years from the date the borrower was no longer enrolled. And then the time limit for recovery actions, that's where the department actually tries to recover against the institution, was 5 years from the written notice of determination. All right. And this is just thinking about, again, the 3 different versions of this bar defense claim process. This was a graphic that up through about 2020 when they stopped making this data available, but for a while the department was showing how many bar defense claims were coming in at different points in time. And you can see by March of 2019 there were about 240, and we just highlight that all of those would be adjudicated pursuant to the Obama era or BDR, either BDR2 or BDR1 standards and processes, because they all predate the Trump administration rule, right? So again, it just highlights that the real volume of BDR claims are going to be under those older standards, not under the Trump era standards. All right, so here we get to our first secret word. And I'll just ask you to go ahead and click the correct radio button. If we'd had more time to prepare, maybe we would have done something along the lines of the team that's going to win the Super Bowl this week. Those of you who listen to these presentations on a regular basis know that I'm a Louisiana guy, so we are quite pleased for Joe Burrow and Jamar Chase, both LSU alums. And also the city of St. Louis does not have a lot of love for the Los Angeles Rams, so I think a lot of folks in this area will be pulling for our friends in Cincinnati. All right. So that's about 30 seconds. Hope you had time to click that radio button and indicate that you have selected the first secret word. And with that, we'll move on to the sort of the meat and potatoes of the session here, and then towards our friend and colleague, Mr. Fink. Jeff, hope you're doing well. So the first question I've got for you how will I know, now this is from the perspective of an institution, right? How will I know when a student has filed a bar defense application with the department?
Well, thank you, Aaron. Good afternoon to everybody. With the departments, you think this is a fairly obvious answer to this question, but given the backlog of applications with the department really arose during the Trump administration, because during the Obama administration you had people really encouraging students to submit borrower defense complaints with the department. And you have these organizations out there actively soliciting students to do that. If you search the web, you can find all kinds of organizations saying you should ask for relief from your student loans. And during the Trump administration, there was a slow processing. In fact, almost an 18-month pause, if you will, where virtually no applications were being decided. And so there was a lawsuit over that, and because of the lawsuit, the department finally got back to looking into them and starting to get to them. But it really wasn't until Biden got elected, the Biden administration took over, that the department's been back in full gear in deciding them. So you could have student complaints, BDR applications against your school that were filed years ago. They're just now finally being gotten around to by the department. So how will you know? Well, you're not going to know, in all likelihood, until the department sends you a notice saying, we have a complaint from student John Doe, and we want you to look at it, and we want you to respond. And they're going to respond. They'll probably tell you, look, you're going to respond in 30 days or whatever. You can ask for an extension of time, but you're going to hear from the department when they want you to respond. Now, the wrinkle in this, and my experience in this really stems from last fall on BDR complaints and getting enmeshed in this. When we had a client come to us, I believe it was last August, where we had over 300 student complaints that had been piling up against a school, and the department sent them all out at once within a matter of 2 or 3 days to our client and said, well, you got all these complaints, we want you to respond. We want you to respond within 30 days. Now, the Ed did grant us additional time, gave us an extra 2 to 3 months to respond, but it shows that there was a backlog there, and it wasn't like the department was sending these student complaints to you as it was receiving them. The complaints were piling up, and they were sending them out in huge batches. And I know our client was not the only one to face this. We've heard of other schools getting hundreds, if not thousands, student complaints all at one time from the department with a demand that the school respond within a few weeks. So you will hear from the department. You'll get it probably an email, and they'll send you a link, and there'll be a confidential site, secure website where you'll go and you'll download what the student complaint is. And if you're lucky, hopefully there's just one complaint. If you're unlucky, you might be facing dozens or 100 at one time if there's a backlog and the department has chosen to send them all to you at one time.
Then Jeff, I'll just jump in and say, you know, we have other clients who have received 1 or 2 and have received them more recently and more contemporaneous to when they were filed. And so my great hope is, obviously out of fairness both to borrowers and to institutions, that on a go-forward basis, claims will be sent along on a rolling basis, right? So you'll get, if you have 1 or 2, then they'll come on over and you can start considering them. But it is certainly the case, at least right now under the law, that the department is not obligated to provide you with those complaints within any particular time frame. So at least to my knowledge, there is no regulation that requires that the department within so many days of receiving a claim produce that claim to institutions or act on it in general, right? I'm hopeful that after this backlog, which is not insignificant. I mean, as Jeff said, there have just been lots of challenges with all these complaints coming in, and the process is being heatedly debated, and then this sort of complicated overlapping framework and administrations coming and going. You know, the real losers in all of this have been you all and borrowers. I mean, both. Everyone needs efficient adjudication of these claims so they can put things to bed and move on. We think the department's intent is to try to do that for certain, but it has just, for one reason or another, not been possible, and it has resulted in this rather unfair scenario of institutions at times receiving complaints that have come in over a literally. I mean, I don't know, Jeff, did you get a sense anecdotally from the ones that we've done? I mean, what was any sense what the broadest year span was, like from the oldest to the most recent? How many years might have been rolled up in one of these deliveries?
Yeah, sure. It's actually several years, and we had some dating back over 2.5 years. And the reason you're able to tell, not only are they dated, the applications are dated, but the department has used different form applications within the last couple of years. During the Obama administration, they had a much more detailed one, and where they really were prompting students and kind of like almost leading students into making accusations, whereas during the DeVos tenure as secretary, it was more of an open-ended one. So you have these different form applications from all different periods of time dating several years back. And you could tell there was a big backlog on these complaints.
Yeah, interesting. All right. So I got another question for you, Jeff. Did I skip one here?
Well, we're going to ask, what do you do? What's your next step after you get this
BDR
application from the department? You've been notified.
That's what happens.
Okay. Well, first thing is not to panic. Second is don't ignore the email, because the issue is not going to go away. But more seriously, you ought to look initially and see what the Ed's department, what the Ed's deadline is for responding, because they've been very aggressive in terms of our client. They sent out over 300 of these at once, and we're expecting us to respond within 30 days on all 300, which wasn't realistic. So I would, if you think you look at it and you've got a bunch of these, or even if you just got a few and think it's going to take you a while to be able to respond, you might want to ask for your extension of time with the department early on. And in my experience, the department has been somewhat reasonable. They kind of set out the 30 days expecting that schools are going to ask for additional time. Okay, put that to the side, because that's not the big issue, really. I mean, yes, you're going to need to respond to the department. They'll give you enough time to respond. What you really need to do is just carefully scrutinize and review the student's application from top to bottom. And like I said, there's a couple different forms that are being used. There's one form that's really just a 2-pager, and it's just open-ended. And it just kind of, the student had to put everything in there, and there was really no prompting. Whereas the different forms, especially came out during the Obama administration, where it was very detailed, and they had all these check boxes, like saying, my school lied to me about employment, or my school lied to me about accreditation, or they use the word misrepresented. They don't use the word lied, but they use misrepresented, all these check boxes, and almost prompting students to pick these different allegations in there. Look over the application carefully from top to bottom and figure out what exactly is the student saying in here. What is this, a complaint about employment representations, about accreditation, transferability of credits? Figure out what everything is that the student is complaining about, and then ask yourself, is the student alleging any type of conduct that can lead to a borrower discharge? You have to remember that not everything, not every woe or any complaint by a student can necessarily get them out of their student loans. To have a BDR claim under the regulation, you generally have to have a misrepresentation, or you have to have a breach of promise or a contract by your school. And the most common ones are about jobs and employment and salary prospects, transferability of credits from your school to other schools, and accreditation issues. They might say, you told me you're accredited and you really weren't. So you look for those and you see, is there anything in there that can qualify? Look for things that don't qualify for a BDR complaint. In this project we had for the client last fall, there were several students who were complaining about things that don't qualify for a discharge of their student loans. Even if they're right, even if their complaint had basis, had merit, it didn't matter, because they weren't complaining about anything that could lead to a discharge. They didn't have a misrepresentation or a breach of contract. And the Ed, in its application forms, has told the students there are these various kinds of conduct that don't cut it. You're not going to get out of your student loans if all you're complaining about are these things. And some of those things that don't cut it, one is the general quality of education, or the reasonableness of the faculty conduct in providing educational services. The conduct has to directly relate to enrollment or continuing enrollment or the educational services, and it has to be a misrepresentation or a breach of a promise or a contract between the student and your school. Stuff like personal injury. So if a student gets hurt, slips and falls on campus, well, that doesn't get them out of their student loans. Or if they claim sexual harassment or civil rights violations, or they've been defamed by the faculty or administration, or their property got damaged, that doesn't get them out of their student loans. So like I said, it has to be a misrepresentation, a breach of contract, that type of thing. And if you notice that all they're alleging in their complaint is stuff that doesn't qualify, well, you want to let the department know that. I would not assume that the department is going to know that on their own and say, well, the student hasn't alleged anything that could qualify for a discharge. Don't assume that. I think you need to highlight that for the department in your response. Look at that application also, because sometimes, and we noticed this in our review for the client last year, there's some gold nuggets in those applications from time to time. The department has helped prompt the student to do things, but a lot of times those prompts the student ignores or answers in a way that rebuts or disproves their own allegations. Some of the form questions in these applications, depending on the form they use, it might be like, well, did you rely upon a promise of employment? And for whatever reason, the student might check no, or they may not give any explanation. They might ask, there's a question on the form, was the alleged misrepresentation the basis of or pivotal to your decision to attend the school? And sometimes they might leave it blank. And if they leave it blank, I'd say, well, they didn't say yes, so use that against them. They might also be asked, what is the total monetary loss associated because of the misrepresentation? And they might just leave the dollar amount at zero, which for all I know could be a pre-populated amount in the form when you go on the web to do it. But if the student wasn't motivated enough to change that from zero to something, I would use that against them and say, look, the student said they had no damage. Use that against them. Another important thing though, at the outset too, keep in mind is that the BDR process can only apply to direct loans from the federal government. If it's not a direct loan, you can't do a BDR discharge of it. The direct loan program began in full earnest and became the exclusive federal loan program starting in July 2010. So if it's after July 2010, you can pretty much safely assume that any federal student loans are going to be direct loans. However, if it's before July 2010, chances are it's not a direct loan. Now, I acknowledge that there were some direct loans in place before July of 2010, but for the most part, the program that was being used was the federal Stafford loan program, and that was not a direct loan. And so if all you have is students with those kind of loans, those Stafford loans, well, you should point that out to the department and say these loans don't qualify for a BDR discharge. Now, the challenge to that is that the department has been out there encouraging students to refinance their old Stafford loans into something that's called a direct consolidation loan. And so even though while they are at your school and they have Stafford loan that wouldn't qualify for a discharge, if the student even today goes in and consolidates that loan into a direct consolidation loan, voila, that springs in their ability to then discharge that direct consolidation loan based on alleged lies, misrepresentations, or contractual breaches by your school from 15, 20 years ago when all they originally had was Stafford loans. So that's out there too. You can check on your loans. You should be able to hopefully check from your systems what kind of loans the student has. But you also probably will need to look at the student loan database to figure out if the student has refinanced any of its old loans into these new direct consolidation loans. So be on the lookout for that, because in our project last year for our client, there were many students who didn't have any direct loans, didn't even have any direct consolidation loans, and obviously that's something you want to highlight for the department so the department doesn't start discharging loans and then trying to come back to you trying to get money back.
So Jeff, you rightly so been focused here on these initial steps, what you're going to do when you first get that complaint, making sure you understand whether it's one or many and the time frame, potentially pushing back to get an extension of time if you're dealing with a high number or high volume of complaints. And then we talked about, sort of that initial assessment, looking over these things, the complaints themselves, trying to make sure we understand the different pieces of the complaint, exactly what's being alleged, importantly, whether what's being alleged actually constitutes a bar defense. And by the way, I'll just note as an aside, I have seen that same issue for many years in the context of false certification. You know, you'll see servicers who work for the department and are managing false certification claims that will call institutions and say, we've got this claim, can you please provide information? And you say, well, can I see the application? And occasionally you look at it and it doesn't assert anything that represents a false certification. And I've had those conversations with those servicers, and I said, well, I understand the student's complaining, but the conduct does not constitute a false certification under the law. And that can even be a little confusing sometimes to those contractors. But it's a really important point that Jeff makes. You know, not everything constitutes a bar defense claim, and making sure that even if you assume the asserted facts are true, if they still would not represent a bar defense claim, you've got to point that out to the department. Jeff, also, you made this really important point, I think, that don't assume that the department is vetting these concepts. I don't think that any administration is taking the time to determine whether or not, at least not initially, whether or not they think, you know, these types of issues exist any more than they do with a lot of other types of discharges. I think the initial effort is to get information over to the school and to trust that you all will point that kind of thing out. So don't assume that the department is vetting these to determine whether or not they represent a bar defense on their face. But Jeff, you got this initial assessment, all these really good ideas. What do you do after you've completed that initial assessment? So what are sort of the next steps in the process that you would recommend?
Sure. Well, after you've screened the application, you looked at it from top to bottom, figured out what the student's alleging, your next step has to be, well, are these allegations true? And hopefully the allegations are untrue. Hopefully you did not make any misrepresentations. You didn't breach any promises. Your challenge, though, is going to be to respond to the department and convince the department that what the student's saying is simply untrue. And so how are you going to do that? Well, you're going to have to investigate the facts as best as you can, and you may be at a disadvantage because you have a student who may have been at your school 10, 15, 20 years ago. We had that with our client last fall. We had student complaints from the late 1990s, early 2000s, over 20 years ago, complaining, saying there were misrepresentations or promises were not met. So what are you going to do? Well, you need to be an effective detective. You need to go out and discover, what do we have? What do we have on hand? Do we have stuff in storage? What are the sources of information that I can draw upon to try to disprove the student's allegations? Common documents you can look, and hopefully you still have them. A lot of your schools may not have the stuff because of your document retention policies. And recall, the department doesn't make you keep student records forever. It's a limited period of time that you're going to have these on hand. But hopefully you still have some of these on hand. And if you don't even have the document specific to the student, if nothing else, hopefully you have the forms that were in use back when the student was at your school. So you might look for the application for admission. You hopefully maybe you had some disclosures and acknowledgments, an enrollment agreement, your school catalog. A lot of times these documents, whether it's one or a combination or several of them, will have disclosures in there and saying, look, we don't promise you a job. We don't promise you any guaranteed salary. By the way, our credits may not transfer to other schools. We don't have control of that. That's up to the receiving institution. We don't guarantee transferability. And like accreditation, we did disclose we're accredited by accreditor X or Y. We never said we are accredited by somebody else. So those are the things you're looking for, is what can you draw upon from your documents, hopefully specific to the student, documents that were given to the student or accessible to the student. But if not, at least you hopefully have the forms that were in use and part of your standard practice would have been seen by the student, so that you can cite those documents back to the department and say, no, what the student's saying just simply isn't true. Places to look,
Jeff,
well, obviously, go
Jeff,
ahead.
I apologize for the interruption, but I just want to emphasize for folks, you know, we get the question, of course, this webinar in part is addressing what you can do when it comes to managing BDR claims, but I'll just suggest you're always going to have folks who make mistakes, and you will always have, I hope it's a very small percentage, but almost every organization will always have at least a small percentage of knuckleheads who do things they shouldn't do, right? You can't prevent that entirely. But one of the things you can do to really try to increase your protections is have good documentation, right? I know a lot of traditional institutions of higher ed, most in fact, don't use an enrollment agreement, though I think some of that may be changing. But you still have disclosures that you make, right? Some that are required, some you choose to make for your own legal protection. And I just want to emphasize that slide that we just left where we talk about the importance of enrollment agreements and pre-enrollment and orientation disclosures. A lot of what is being alleged by students and borrowers as the basis for claims is that things were misrepresented. In most cases, there's not going to be an ability to go back in time and hear a recording or watch a video. But you can point to documentation that demonstrates that if it was said, it's certainly not consistent with what we have in writing. This is what, our policy says, our transferability of credit policy, our enrollment policy, et cetera. And the student received it before enrollment or at the time of enrollment and registration, and here they even sign an acknowledged receipt. That's incredibly important. So if you're watching this and you're interested in figuring out how to mitigate risk, please keep in mind that having great enrollment and pre-enrollment documentation can go and catalogs, right? All of that can go a long way to protecting you. And if your documentation isn't great, then you are really undermining your ability to protect yourself down the road.
Absolutely, and I'd also recommend, even if you don't keep student files beyond what you're required to, at least keep the form, your school catalogs, your form enrollment agreements, your form disclosures that for as long as you can, so that you have a student comes 20 years later, maybe you don't have the record specific to the student, but at least you have the form documents that you were using at the time. So, but moving on here, in terms of what kind of documents you got, make sure you look at every conceivable place you might have stuff. You've got your physical locations, you've got your electronic files, your paper files. Think through all the different kinds of files you have. Social media. Sometimes you could look at social media to disprove some student allegations. Maybe their Facebook page is public. You go on that and find out, hey, they've got a really good job after all, even though they say they don't have any work. Just make sure you're digging in the right places. Beyond the documents, what's even better, if you're fortunate enough, are the key school employees who dealt with the student or know stuff, are they still with you? Can you talk with them? Will they come back and confirm and say, no, we didn't say this, we never did any of this? It'd be great if you can mention specific employees and say, well, no, I talked to Jane, and she says, no, I dealt with John Doe, student John Doe, and I never told him this. We never said that. That's another good source of information, too, is if you can talk to your employees. And the third point, too, and which came up last fall, is investigate the student's employment history if you can. I know a lot of times after the student graduates, you're only looking at whether the student's employed quickly after the student has graduated because you're doing it for placement purposes. But there are ways to investigate a student's employment months or years after the fact and go back and see, well, maybe the student really did get a job, and maybe that job really is in field to his program of study at your school. So he's coming here and saying, well, I could never find a job. Well, that may not be true, and sometimes you need to dig down and investigate that and figure that out.
All right. So moving on through the process sort of chronologically here, Jeff, after they've completed this process of investigating facts and they've really looked under every rock and done what they can to find out whether there's merit to these claims, they have to prepare a response, right? What does that response look like?
Absolutely. We have a lot of discretion and choice in what your response is going to look like. You could make it short or as long as you want. I think it benefits you to make your response as detailed as possible to the department. I think you want to send a signal of strength to the department that you're not going to lie down, that you're not going to take it without a fight if the school comes after you and it discharges the student's loans and then comes after you. So you want to tell them, hey, because I think the department's expecting a lot of schools not to really fight back a lot on these. I think it helps you and gives you, puts you in good standing to show the department that you're serious about this and that you're not ignoring it and that you've investigated, and the results of our investigation are, hey, there's no reason to grant this student a discharge from his or her loan. And the responses we did last year for the client, kind of the format we use, and I think this is a good format, is you start off with the student background information to make it easy for the department official to know what complaint you're talking about. So you give the case number, the name, social security number, but only the last 4 digits. Put in the student ID number. Put in the dates of attendance. I think that's critical, because that way, hopefully, it'll signal to the department official, hey, what BDR framework are we working under? How long ago did the student attend? Put in what the student's program is. Did the student graduate? If so, when? Put that in, and then what credential was awarded to the student. That's the background information, pretty non-controversial. After that, consider your initial arguments that you might have or you might not have about the student's circumstances. The student had no direct loans relating to his education at your school. Let's say that. I would say that right up front. Say there's no way that this student can get a discharge for many loans because, by the way, he didn't have any direct loans. After that, say, wait, student has not alleged a sufficient basis for a borrower defense discharge. Recall that it has to be a misrepresentation or a breach of a contractual promise to be eligible for a discharge. If all the student's complaining about is disciplinary matters or academic disputes, we'll say that. Say, hey, this is all the student is complaining about. This doesn't cut it. You cannot discharge the student's loans based on what the student's alleging. And something else you can point out is just say, hey, there's no evidence for this. Most of the complaints, actually I think every one of the complaints that our client got last fall, all we got from the department was the application. They had no evidence. Even though the student is invited to submit evidence along with the application, there was no documents, there's no evidence. It's just the student saying that something happened. And then it's just basically trying to hope that it's the student's word versus the school's word on that. I would go back and tell the department, so wait a minute, there's no evidence supporting what this student is alleging. And put that up in the front. After that, you might want to consider some legal arguments. Statute of Limitations. A lot of these student complaints come from 10, 15, 20 years ago. And if a student had tried to go to court to do, and file this complaint, they'd get bounced out of court because it's just too little too late. So you might want to put that in there and mention it. In some of the BDR application forms, the student is asked, when did you discover that the information that the school provided was inaccurate? In some cases, the students have said, hey, it was like 10 years ago. I would highlight that for the department and say, well, wait a minute. They said 10 years ago they knew about it, and yet they waited this long. It's too late. They shouldn't get a discharge. And another point here, which you don't necessarily have to put in, it won't prejudice you, it won't waive any of your rights, but I like to do this is to raise the flag for the department and say, wait a minute, your whole process here is unconstitutional, and you have no statutory authority for what you're doing here, because this process, you're not giving the school a hearing to contest what the student's saying. All you're doing is giving us a chance to respond in writing to what the student says, but after that, there's not going to be a hearing. We don't get a chance to cross-examine the student and ask him or her questions that might undermine what she's alleging. And there's no independent and impartial hearing officer assigned to this. These cases, these thousands of complaints that are pending are all going to be decided by various officials within the department. And who knows how long they're going to have to spend on these, how much time they're going to be budgeted to consider these. As far as we know, it could be as little as 5, 10, 15 minutes. We just don't know. And that's a big problem. We don't know.
That's right. And I'll just remind folks, I mentioned earlier that just keep in mind there are 2 processes, right? So the first is the claim itself that's adjudicated by a staff member at the department. So somebody puts in that application, they forward the application to the school and say, we want you to respond to this and give us a bunch of additional information. And I know Jeff's going to talk about this sort of additional information request as well. But all of this is adjudicated by the staffer. They gather everything and they make a decision. And then the discharge is made based on that staffer's decision. There is a secondary process, the recovery process, where the department can actually attempt to recover from the school. And that process does involve more due process. It does involve opportunities for the school. It's in front of an administrative law judge, at least as of right now, or hearing official. But the key point that Jeff is making here, which I think is a really important one, is by the time you get to that process, the loan's already been discharged. So in a sense, now you're then trying to prove to the ALJ that the prior claim decision that was made was inappropriate. Jeff's point is, in the initial claim process, where the staffer is deciding whether or not to discharge the loan, and as such, at bottom, whether or not the school did something wrong in the staffer's view, you don't have these same types of protections. And so the argument is that process, it is resolving a claim or allegations between the student and the school, and you should have these types of significant statutory and other protections, even at that initial claim process. And of course, by the way, this has all been argued ad nauseum every time we've had negotiated rulemaking along the way on this rule, and it's been debated back and forth. And I think the department, both administrations, because remember, the Trump administration could have done away with that initial staff process, and they didn't. And I think that's because the department feels like it would be impossible to process any volume of claims timely if you had to go before an administrative law judge for every single one. But it does not obviate Jeff's point, which is that the initial process lacks protections for institutions.
Right. And so continuing on with how your response should be, after you've laid out the initial objections to the complaint, maybe some legal arguments if you want to include them, you just need to go methodically and address the student's allegations one by one. And I would just set out allegation number one. Student says X, untrue because of these reasons. And if you can, I unequivocally deny it, but I would cite and quote from documents you have, hopefully specific to the student, but if not, your form documents to say it's untrue. And then if you can, mention specific employees who say they dealt with the student, and the student's allegations simply are untrue. Go allegation by allegation, 1, 2, 3, 4, 5, and just do it methodically, one after another. And then when you have that done, but make sure if you're citing documents and stuff, make sure you send those documents to the department. Don't just send a written response back and say, hey, our catalog says X, or our enrollment agreement says this, or a disclosure said this. Be sure to send those documents to the department so the department's not just taking your word for it. They can look and they can see on paper that these allegations made by the student simply aren't true.
Hey, Jeff, because we've got 3 minutes left, I know
Sure.
this is sort of our last question. What should schools do if the department requests that they produce documents and information? This is an important point. But I want to skip ahead real quick for folks who may need to get off the phone here in 2 minutes. And here's our second secret word. So if you are, particularly if you're looking for that CLE credit today, please make sure here at the end to take a second. Oh, we do have something relating to this upcoming weekend's activities. That's good. Make sure you fill in that radio button. So I'll wait just a couple more seconds here, and then Jeff, I'm going to skip back to that last question because I think that's a really important point. And then we also, Jeff and I could stay on for about 5 or 10 minutes into the next hour, and we do have some questions, and I want to try to get to some of those questions as well. All right, so Jeff, I'm going to skip back to
Sure. Absolutely.
this, and I'll ask you to make this the last question, and then we'll try to get into some Q&A.
Yeah, absolutely. Last fall, when our client got these 300-plus student applications, they also got a request from the department for a bunch of documents and information, some of which arguably related to the student complaints, but much of which didn't. And so the question is, well, do you have to respond to this? Do you have to produce this stuff? And under the BDR framework, the regulations and stuff, the department really doesn't have any direct authority to require you to produce and cough up stuff that it wants you to produce. That being said, the department does have other means and ways to try to compel you to produce information. So you kind of have to walk a fine line here in deciding how much you should produce. Obviously, the more you produce, I would assume you're going to look more favorable to the department, and maybe in turn that'll help in deciding the applications. But on the other hand, I mean, technically you're not required to produce anything. The department doesn't really have that power within the BDR framework. And anyway, and lastly, if I could, Aaron, I just wanted to wrap up quickly here, and then we'll answer these questions. Is the process, what happens after you've responded? And some of the questions ask, well, will the borrower get to know how the school responded? In the regulations, it doesn't say. And we really don't know what the department's going to do once the school submits its response back to the department. And the department could share the school's response with the borrower and ask the borrower, hey, what do you think about this? And that's a possibility. We really don't know based on what the regulations say. In any event, the department's going to look at the stuff, and when it makes its decision, it's supposed to issue a written decision. The regulations say the decision goes to the student. It's silent on whether the school will even hear about it. So the department, in theory, could discharge a student's loan and not tell the school about it right away. It may never tell the school about it. And if the department wants to, and it grants the discharge and it wants to, it can go after the school on a recovery action, as you mentioned, Aaron, but it's not required to. And I think a big question here is, given the thousands and thousands of student borrower defense complaints that are out there, if the department starts granting these on a high basis and then comes after the schools seeking recovery of hundreds or thousands of these, the school has a right to an appeal and can contest and say, no, I want a hearing before somebody in the Office of Hearings and Appeals. In that case, you could have thousands of appeals, one for every student complaint out there where the department is granted a discharge. Is the department really going to want to go down that road? Or, in theory, if it wants, it could just discharge the student loans, never tell the schools about it, and never go after the schools in a recovery action, which is a complete possibility. And the department just say, well, we'll just eat the money. I mean, you've heard a lot of talk about, a lot of pressure within Congress and on the department to forgive student loans. Well, this is a way they could do it. They could just grant a borrower discharge on the loan and just say, well, it's too much work to go after the school, and just leave the schools alone. So that's something that could happen. So your student could get a discharge. You may never hear about it. But if you do, you'll have a right to appeal and contest that and have a right to a hearing, in which case you can present all your evidence that you presented before and whatever additional stuff you can muster to avoid liability if the department comes after you.
That's right. I do, just one point of clarification. The BDR 3, which is the Trump-era rule, does provide a little more process for schools. So in theory, if you had a loan, an underlying loan that was subject to the BDR 3 process, the department is obligated to afford schools, even at that claim adjudication stage, to afford schools a little more opportunity to present evidence. They're required to review it. They are required to issue the decision simultaneously to both parties. But to Jeff's point and the point we made earlier, the vast majority of loans are not subject to the BDR 3 process. None of the ones that we have dealt with to date have been under BDR 3. They have all involved loans that were issued before July 1, 2020. So, Jeff, I think you're absolutely right. As a practical matter, I think in most cases schools are not going to have that kind of additional process. If you're lucky, you might, and if you've got a BDR claim, that's not lucky, but if you are lucky, it will be at least subject to the BDR 3 framework, which gives you a few more process rights. Okay, so we did the secret word. Just very quickly, as you all know, if you listen in frequently, please check out our blog. We write about things frequently. We have another post, actually, it's coming up here pretty soon, and we'll have a lot of content, I think, coming up this year on the neg reg, especially through webinars like this. We're going to try to cover a lot of the proposed regulations. Our webinars, once we do them, are always free and available on demand. You just go to our TCLE website. You can't get CLE for watching a recorded webinar. Unfortunately, you got to listen live to get the CLE. But if you just want the information, you are very welcome to go check these out, including this webinar, which ought to be up in just a couple of days. Please keep an eye out. We also are now doing training and other types of series on our YouTube page. When we do that, we make announcements. We have a really nice 6-parter we did on Title IX a couple of years ago in July 2020, and we do expect to do something similar for the new Title IX rule this administration is going to be putting out. And then finally, please keep a watch for our white papers, because we did, for example, there were 3 we did last year. One of those, actually the first one here you see on the left, had to do with the financial responsibility requirements under the bar defense to repayment rule, at least the one that was negotiated under the Trump administration, and which is still in effect. Here's our disclaimer, which I always like to put up when we get the questions. And with that, I'll start the first one, and we'll see what we can answer here in the next 6 or 7 minutes. First of all, from our longtime listener and Golden Gopher, What if you've already repaid the loan? I think that means if the borrower's already repaid the loan, can they then submit a claim and get paid back? It depends. So it is definitely the current administration's view that even if a borrower has paid in a certain amount on the loan, if they have a valid claim and they file that claim within the appropriate time frame, that they should be able to get their money back. And so that literally means if they've already paid $10K in and the department discharges the loans, the department writes them a check for $10,000. Under BDR 3 and in other places, sometimes that ability to recover funds already paid in has been impacted by statute of limitations provisions. So in other words, at times the proposal has been, and we may see this in BDR 4, if you file the claim within so many years of, leaving the institution, you can get it all back. If you file after that point, you can't recover money you've already paid in, but you could still get a discharge of funds not already paid. So it is generally this administration's view that students ought to be able to get it all back, but there have been sometimes a negotiation sort of splitting the difference based on statute of limitation considerations has been on the table.
Yeah, Aaron, if I can chime in, on the BDR 2, it's typically it's a 6-year limitation period, from 6 years from when the contract was breached or when the student discovered or should have discovered the misrepresentation. So if you've got a student who's repaid his loan 10 years ago and should have learned that he was lied to back then, well, that's too late. But your point, though, it's a different statute of limitations on how far back you can go to recover amounts you've already paid. But beyond that, though, there's no limitation on trying to get a discharge from your future obligation.
Yeah. And again, the current administration, their preference would be that a student could discharge all of the loan, paid or not paid, at any point in time if they are successful with their BDR application. Let's see. We've got one person who accurately notes that, again, echoing this notion that you could have, right now, you could in theory have someone who has different loans made across different, frameworks that are impacted by these different processes and standards. And they say, so if I get a claim adjudicated, and I've got loans that fit into BDR 1, BDR 2, and BDR 3, do they somehow rationalize that to one standard? Does it all get rolled up? No, they're really supposed to split out the loans and adjudicate the claim differently for the amounts under each framework. So in theory, if I had loans, that straddled BDR 1 or BDR 2 and BDR 3, they should be split out, and you should have two different claims for those amounts that are considered separately, which, of course, in practice, I think is unlikely to happen. It's a great point. Someone asked, will the email, if you get a notice about a BDR claim, does it go to the school officials listed on the e-car? So our experience has been that it goes, I went and double checked this, and it goes to the president, our CEO that's listed on your e-car. So you may want to notify that person. It's possible that they could be the one who gets the email. I went back and actually looked at a couple of those emails, and they did not copy anyone else but for the president and /CEO listed on the e-card. Now, after the lines of communication were open, they were corresponding with the institution's compliance officer and general counsel, et cetera. But and the claims themselves came in through the institution's some of their Title IV infrastructure, right? Some of these pre-designated boxes that your financial aid administrator uses. But the initial notification of BDR claims went to the president or CEO. Who was listed on the e-car. Also, they don't have a person from whom this information, these letters came. It's from like an email address at the department, and they literally will say, like on the notice, from the BDR claim team. Here, I can tell you exactly what it says. I'm pulling it up here. It says, BD School Evidence. Sincerely, so you correspond with BD School Evidence at ed.gov, and it just says, sincerely, the U.S. Department of Education. So they seem to be working pretty hard not to give you a name that you can contact about these questions, which I thought was pretty interesting. Can students use COVID as a reason for BDR? Fascinating question. So I think if an institution, in theory, were unable to fulfill its contractual obligation to the student, and the reason was because of the pandemic, but the institution did not have in any of its written materials with the student, catalog, registration information, enrollment agreement, a force majeure clause, or something that said, you know, if there's a pandemic, we're not obligated or we can't be held responsible for not fulfilling our contract, then a student could ostensibly claim breach of contract. So what this really begs the question is, you know, you've got all these class action suits right now around the country, mainly focused at traditional higher education, where students are claiming you breached our contract by forcing us to go online during the pandemic. I think the billion-dollar question is whether or not all those students, even if they lose their lawsuits, could file for loan discharge. Most of them would be covered by either BDR2 or BDR3, but many of them could likely claim a breach of contract, particularly if they had loans that were issued prior to, right, July 1, 2020, which is when the BDR3 went into effect. Well, a lot of those folks had loans that were between 17 and 2020, and breach of contract is a valid basis for a claim. I think that is a serious question out there right now. And if I am an institution that has been dealing with one of those class action lawsuits, I would be pretty interested in thinking about the intersection between those claims and bar defense. I also would not invite any plaintiff's attorneys to that meeting. What are your thoughts on the department's role in screening these applications? If there's no claim on the application, right? Let's see here. Sorry, I lost my place there. Why should it even be sent to the school? Jeff, you want to speak to that? I think people are surprised, but my view is the department is really not interested in expending resources screening the application, but is letting the institution bear that burden. You've seen a lot of this.
Well, no, that's right. You'd think there were many student complaints that came in to our client that should never have been sent to us because, for one, they didn't have a direct loan. The student didn't have a direct loan, or the student didn't allege something that could be a basis for a borrower defense discharge. So why are they not screening them? You know, it takes effort, it takes time, and they figure, you know, I'm only going to look at this once. If I'm a department official, I'm going to look at this once. The application comes in. I'm going to give the school a chance to respond, and then when I get the school's response, I'll look at it and make a decision at that point. So that's probably why you're not seeing any screening, because there's just not much incentive for the department to do so.
Yeah, and that's consistent with practice we've seen in other areas, whether it's closed school loan discharge or false certification discharge. The school or the department really puts the onus on the school to flag those types of issues. I mean, we've seen discharges, applications from students who weren't even enrolled when the school closed, you know, or within the applicable time frames, or, you know, I mean, it was just not even a remotely eligible application, and the department just sort of passes it through, and it's up to you to point that out. So we've got to wrap up. Our carriage turns into a pumpkin typically around 15 minutes after. You know, we do have a post-webinar survey, and I mentioned earlier, we're planning on doing a lot of content on all these proposed rules this year. If you'd like more, or you'd like to see more around sort of bar defense claims and litigation in higher education and some of the things, you know, that Jeff and some of our other folks focus on, let us know that. Drop that into the survey, because we're always trying to figure out what folks want to see. I think we tend to skew towards the regulatory stuff going on at the department. As many of you know, that's what I personally do, but would be interested. So if you have thoughts, fill out the survey. Let us know, particularly if this is the kind of stuff you want to hear. We might even could do a brief recap sometime and just a Q&A session or something like that if folks think that would be of interest. Otherwise, thank you so much for tuning in. We deeply appreciate your patronage. We hope you find this helpful. Keep an eye out for future webinars and be safe out there. Have a great day, everybody.